Okay. Welcome to the American Liberties Call. This call is for educational purposes only. It should not be taken as legal advice in any fashion or to advise you about what you should or should not do. Information offered on this call is to assist you in performing your own due diligence before implementing any strategy or procedure. My name is Chris Chapman. I will be your host. I will not be held responsible for any opinions, statements made by anyone on this call. I believe this call is protected under the free speech of the First Amendment. And I would like to give formal notice to any and all government employees and any private citizens that you have 10 days after listening to this call to notify me via email, americanliberties@gmail.com, of any word, phrase, reference, or statement which is inaccurate, incorrect, misleading, or not in full compliance with state and federal law, and give me 30 days to correct and cure any alleged potential flaw. As always, American Liberties intend to be in strict compliance with the law. Now, on with the show. Okay, I'd like to make a correction in that recording. It's been so long, it's americanliberties.llc@gmail.com. Anyhow, I'd like to thank everybody for coming on to the call tonight. We have a series of people that are coming on that I have known or known of for many, many years, and who I deem to be an expert at what they do. Like, for instance, we had Royal Lamar Hardy, we had Paul Hansen, and we got many others that are going to be coming to the call. And each of these people that have their way of doing things, they are knowledgeable, they are experienced, and they have a track record. They're not somebody that makes a lot of claims, and when you go to find out, they're a bunch of losers. I and I don't like really, framing anybody as a loser, because a lot of people are trying. But then again, a lot of people that are trying to get other people to support their try go to prison, and a lot of these people go, "Oh well, next." And so this is not the case. This is a case where people, like I said, they're experienced. And Lysander Venable, who has the he's probably the only that I can say, the only expert. I mean, lawyers, anybody. There's nobody that I know of that is more into the tax court than he is. And, many times people will say, "Well, Chris, you went to tax court." And say, "Yeah, I lost 3 times, man. They walked all over me." And I had some good arguments. In fact, I brought one good argument back again, and they fined me $3,000. So you don't want to follow a footstep where it leads to body parts. Okay, I would never ever suggest going to tax court. However, if the time ever rises again that I should need to even think about going to tax court, I will beg, borrow, and steal to get myself in line to get this man to help me walk through the minefield of tax court. And I don't know anybody else that I would suggest to have you get help in going through tax court. So I'd like to introduce Lysander Venable. Are you there?
I'm here. You can hear me.
Good. Yep, we can hear you. Lysander, tell us a little bit about your background and the things that you do. You got the floor.
Thank you so much. You're very kind with your evaluation of my skills. My skills improved dramatically. I participated in tax court cases probably going back to 2010, 29, and I had the same result everybody has. You know, I got crushed. I took patriot arguments into the tax court and was heavily penalized, generally insulted, and I lost. 2017, I met the gentleman who is on here tonight as what's that phone caller one? Ed, is that you? And
Yes.
from then on, we began a process that we now call intelligent confrontation. The Venable Group now helps people litigate for themselves in tax court without attorneys, and we have had excellent success. Although it is absolutely true that the IRS claims that they win over 90% of their tax court cases, what they don't tell you is that in over half of them, they don't get everything they wanted. So even pro se petitioners, without much help, can reduce their tax bill by going to tax court, and they can extend it out to a great length. For example, we have a client who filed what you guys would call statements of income, and he did that for a number of years back in the mid 2000 teens. His tax court case was just decided after nearly 9 years, and it's still not resolved. He still has options to delay his collections and so forth, which gives you some idea of, that's a reason why you go to tax court at some point. This is what a victory looks like, is that it takes them 10 years to figure out how much money you're going to try to collect it. And then he will still, even then, have options for collections alternatives to levies and liens, so forth. We have won cases in frivolous return penalties. These are very difficult to win, and they frequently fall upon patriot filers, people who file tax returns or various documents that express opinions that are, frankly, I agree with them and they're absolutely accurate, but that the tax court will not tolerate. And to avoid penalties in the tax court, you must avoid those arguments. Just give a little quick review of the tax court. It's an Article 1 court. It was set up back in the 20s as the Board of Taxation, and over the years it morphed into an Article 1 court. In 1969, it became an official court. There is still some controversy as to whether it's an agency of the executive branch of the government or not, but it's neither here nor there. What it is the only federal judicial venue where you can contest your taxes without first paying them. And it's not for everybody, but it's for people who are working in jobs where their income and revenues are reported to the IRS by their employer, or people who receive 1099s who want to controvert them or contest them, test their liabilities in their payment method. And if you're somebody who doesn't receive any information returns, you work in the private economy and you work privately, and you never hear from the IRS, no, tax card's not for you. But if you find yourself receiving nasty notices threatening to assess tax against you or threatening to collect taxes that have already been assessed, then the tax court is really your very best venue to go. Because you can't get these guys to back off just by claiming that you're not a taxpayer. It doesn't matter. They don't care.
I got a question regarding the Article 1 court being the executive branch of government. I believe the Supreme Court is ruling on such decisions as these administrative courts, which in my mind, they're all administrative.
They're all, yeah. Well, they differ from Article 3 courts in that the judges are not permanently appointed. Their compensation can be reduced. you give up a great many rights. For example, you don't have the right to a jury, and the burden of proof is turned on its head. The IRS, the petitioners in the tax court have the burden of proof, generally speaking, except in certain certain accepted circumstances. If there are two types of cases. Let's talk about the two different types of cases first. One of them is pre-assessment. There are two major types of cases. There are many others. But in the types of cases that we generally handle are for notice of deficiency. Notice of deficiency is a pre-assessment document. The IRS is when they send you a notice of deficiency, what they're telling you is that we have audited whatever information we happen to have about you, which may or may not be accurate or reliable. We've audited it. We've decided that you owe so and so much in tax. If you want to contest it, you have 90 days to take this to the tax court. Otherwise, they can and will assess it against you. Whether you filed or not, it doesn't matter. They will make up these bootleg forms called substitutes for return. The courts will accept them, and you will then owe the money. At that point, you have a second tax court option, which is collections. Before 1998, 30 days after the assessment, you were looking at a levy. It would already have arrived. And but in 1998, with the Tax Reform Act, taxpayers got a lot of benefits and a lot of ability to actually fight what the IRS was claiming in such a high-handed fashion. So now you can contest not only the proposed assessment, but you can contest the intrusiveness or the legitimacy of a levy or the placement of lien against your property. These are all available for contesting in the tax court. And there's no other real place, to pay the tax and try and get it back in district court. It's just a fool's errand. It's never going to. But using procedure and twisting their own rules against them, you can in fact make a great deal of progress and cause them a great deal of trouble in the tax court.
You're fading out a little bit there.
Okay, sorry. I gotta get a little closer to this microphone.
Yeah. When is the best time? You might have said it, but I don't know if I heard you clearly. When is the best time to? First of all, you're giving jurisdiction by going into tax court. Am I right?
You are indeed. It's always a little ironic for us to see people who petition the tax court and then contest the tax court's jurisdiction.
Yeah.
What a petition does is it actually invokes. It says to the tax court, you have jurisdiction to settle this matter, and I believe you do because I'm sending you this petition that I want you to rule on.
So is it your goal to get the IRS commissioner to state that we dismiss it for lack of jurisdiction?
Well, there's a misunderstanding. There's something that became popular in the last couple of years, and my partner and I call it the kitchen sink petition, where for some reason these people have come to believe that by filing a petition for the last 20 tax years and claiming that they did not receive a notice of deficiency for those 20 tax years, they are seeking to have the court dismiss their case for lack of jurisdiction. Now, if you don't have notices of deficiency for any of those years, and you don't have a notice of determination on a collections action, the court really doesn't have jurisdiction. But what the people who are filing these petitions believe is they believe that by getting the tax court to say that it doesn't have jurisdiction over them, that they're actually being relieved of IRS jurisdiction. This is a really, really big mistake. When the tax court tells you they don't have jurisdiction, that doesn't mean anything about the IRS.
Right, but I mean, if you're using the jurisdiction of the tax court, I give you, in other words, people are saying, there's one guy out in Texas, I can't remember his name, but he said, just file, you never receive a notice of deficiency and a notice of something else. And he said the commissioner will come back and wants to dismiss it for lack of jurisdiction. And in his mind, or what he's promoting, is that because they never given you a verifiable certifiable notice of deficiency, they will ask the court to dismiss it for lack of jurisdiction. Now, does that mean that the IRS has no jurisdiction over the respondent, or he's asking the court to say we don't have any jurisdiction in this instant matter?
What they're actually asking is the second question, yeah, in this instant matter, because
Right.
the tax court jurisdiction is statutory. You know, there's everything the tax court has jurisdiction to do. There's a statute that gives that jurisdiction to the tax court. Now, we talk mostly about notice of deficiency and collection due process hearings, but there are many other items over which they have jurisdiction. For example, spousal relief. Ed, help me out here. What are the dozens of other things? We only, 90% of our time is taken up with NODs and collections. But,
the tax court has jurisdiction over spousal relief claims. You can claim innocent spouse relief against any liability that they've assessed, worker classification determinations. You know, if you have a nonprofit or 501c3 and IRS might have revoked your tax exempt status, you can take that to the tax court.
Right.
Certain declaratory judgments, but 90% of the tax court's caseload is notices of deficiency.
Right. So back to the question. Without a notice of deficiency or a notice of determination in a collections case, the tax court does not have jurisdiction over that case, but that doesn't relieve, that doesn't change or alter the IRS's power to determine and levy your taxes. They've got the power. I mean, don't remind me. I know all the Patriot arguments, and yes, they're correct. When I speak here, I'm talking about reality rather than theory.
Well, I've seen a lot of people file these. There's a guy claims to live in Paris, but I think he's in Michigan. But he did the revocation of election. And I know some people, to me, if France, so to speak, has a law, why should I do a revocation of election to eliminate from a law that in the first instance didn't apply to me to begin with?
Right. If your position is the U.S. national, I'm not a U.S. citizen, the District of Columbia and territories are the United States as opposed to all the 50 states. Yeah, you're right. It doesn't make any sense to make that argument, to withdraw yourself from things that don't apply to you anyway. Why bother?
Yeah, I think somebody tries to make a big stew out of an argument where you can really narrow it down, and save yourself a lot of headaches, a lot of trouble, and an awful lot of money. But to each his own. Like I said, I'm not saying that people are wrong by doing it. I know people that have claimed success, but on the other hand, success is measured by years. I went in front of the grand jury in 2007 and shut the door on them. And then in 2017, they're sending, 10 years later, they're sending me letters of the same years that I shut them down in front of the grand jury at 10 years. So you never know when you go to the mailbox what kind of a letter you're going to be receiving.
Once you're in that system, you stay in it. It's hard to get out.
Well, Chappie, if I can jump in, you hit on a great point, is what happens when you go to that mailbox and you've got an IRS and it's usually a certified letter, and you open it up and it's a notice of deficiency. They're saying unless you petition the United States Tax Court within 90 days from the date of this letter, we're going to assess the tax that we've determined you owe. So what are your options? You have two. You can do what the old, before the tax court was instituted in 1924, you can pay first and litigate later. You can go to a district court, or you can go to the United States Court of Federal Claims and litigate in a refund suit after you make a refund claim to the IRS. Or, without paying, you can petition the tax court and you can shut the IRS down immediately. They can't assess the tax, and without the assessment, they can't collect it. So as long as you keep the IRS in the tax court, they can't touch you. So and the same thing happens on the collection end. If you happen to miss your tax court notice of deficiency, or you did litigate it and you lost, well, then they have to start another procedure. They have to send you a final notice of intent to levy, or file a notice of federal tax lien against you. Okay, well, that gives you collection due process rights. You have 30 days to request a collection due process hearing. If you do that, you shut down the collection action. Of course, the lien filing has already occurred, but they can't levy against your bank account. They can't take your wages. They can't take your pension. We've had cases where they've seized 100% of somebody's Social Security benefits. They're not going to do that. And if IRS appeals, rules against you in a notice of determination, here comes another certified letter. You've got 30 days to petition the tax court if you disagree. If you petition, you shut down collection. You keep that collection freeze on. So the tax court by no means is an ideal body. You're not going to get a fair tribunal here. But if you play it right, you could stop the assessment from going forward. You could stop the collection if the assessment has occurred. You can keep these guys tied up for years. They only have certain resources that they can spend on any given case. And while they're messing with you, they're not messing with somebody else because they can't get to them. So you said success was measured in years, and that's what we do.
Yeah, and on the now when people write exempt, on their W-4s, I always tell them what bases are you exempting yourself from, or what bases are you exempt? And a lot of them say, "Well, I just write exempt because I'm exempt." Well, you don't even know why you're exempt. So when they come after your employer to take your money, you really don't have any argument. So what say you regarding putting the exempt on the W-4?
Yes. Well, that's outside the tax court's jurisdiction, but I know what you're talking about. The IRS will send the employer what's called the lock-in letter. And that letter tells the employer, well, under such and such regulation, Title 31, you can go ahead and lock this guy in at the highest possible withholding rate. And for most people, that pretty much satisfies whatever liability during the year the IRS might claim arises. And it's very difficult to get out of, but they've changed the procedure now where they have to come after you, whereas before they would direct the employer, okay, anybody who gives you an exempt W-4, send it to us. Okay, well, you were pretty much going to get locked in under that regime, but they've changed that. So those lock-in letters are not as frequent as they used to be, but they still occur. They're difficult, but there are ways to get around that. That's nothing you can do about it in tax court, though. I just wanted to confirm.
Yeah, okay, good. That's what I want to know. That's not a tax court issue. The way when people do put exempt on the W-4 and they give the basis, then it gives the exempt legitimacy, and then the IRS are less reluctant to write that lock-in letter. But just for the callers, if you have an employer who's willing to work with you, you can write a letter threatening to sue the employer, because the IRS does not have delegation of authority, and you want your employer to write the IRS and say, look, I want to hold this guy's money for 2 weeks. I need a whole harmless letter from you because that son of a gun's going to be suing me. And so I need protection. And the IRS will not do it. They've never done it yet. So that's just a point of that.
If you remember, Chappie, I know you go back a long way. This was a little before my time, but I remember my old mentor, Irwin Schiff, talking to me about Vivian Kellums in the 1950s, who raised this very issue. She was kind of the pioneer of what we know as the tax honesty movement. And, she did fight years for, having not to be an unpaid tax collector, which is what it amounts to when the IRS says the employer has got to collect your withholding tax.
Can you tell us a little bit about your background, because you work with Lysander, and I think it's important to know the experience and the minds behind your group.
Well, like Lysander said, I met him. I knew of him for several years, and I came across him again in 2017, and we got to talking. We decided that, we love the Patriot movement. Each of us has been in the movement for 30 odd years. I started in late 1989. I went to this bookstore in Texas, a half-price bookstore. I found this musty, dusty yellow book that had been 7 years old, How Anybody Can Stop Paying Income Taxes by Irwin Schiff.
Yeah.
And I'm like, Irwin Schiff, kind of vaguely, that name sounds familiar, I don't know. So I started reading the book, and I was just astounded by what I read. I decided I'm going to call her. I'm going to find out where Irwin Schiff is. Where is he? Well, I tracked him down. He was in the Federal Correctional Institute in Morgantown, West Virginia.
Yeah, I was going to say cell block number 9. Yeah.
But that didn't stop me, Chappie, because ordinary person might, the guy ended up in jail. How good could that advice be, and what he said? I started talking to Irwin. He put me in touch with Peter Schiff, his son, who is now on CNBC, famous financial advisor. And I became Irwin Schiff's right-hand man for several years. And then later I was affiliated with Paymon Mateade of Freedom Law School.
Yeah.
And my best alliance to date has been since 2017 with the great Lysander Venable, who you have on the line right now. And Lysander and I have just been, we've taken it to a new level. We're doing things that the Patriot movement has not seen before. We call it intelligent confrontation against the IRS. And now, Chappie, remember the old days when we used to have to troop down to our local law libraries and get the roll of quarters for the copy machine and copy the cases and the laws? Well, they only got supplemented every 6 months.
I had a year parking pass, yeah.
Yeah, we didn't know what was going on. We did the best that we could under the circumstance at the time. But once the internet came in, the World Wide Web came into, popularity, we have access now to everything that an IRS chief counselor, a Department of Justice, tax division attorney, all these guys that we're facing, appeals officer, whoever it is, we've got the access now to information that we didn't have. We should hardly lose a case now, frankly.
Yeah, and it's true. A lot of people, and I express this all the time, is that arguments are for fools. I learned that from Right Way Law. And Rick Schramm, which was a great guy. I really like Rick. He was fun to work with. But he had me or he didn't have me. I mean, I willingly went out and got a lot of speeding tickets so I could go to court and start fighting them. I said, because I could afford it and I had time and I was always in the car. And so, and I had, without prejudice on my driver, on my plates, and the cop said, "Oh, am I going to deal with one of you?" I said, "Not at all. There's no dealing. Just do what you need to do." And quickly, very quickly, I learned that I never have to pay a traffic ticket anymore. And people want to drive without a license and without a tag on their car, painting a big target on their back. And I was guilty. I was driving without expired tag, and no driver's license, and my daughter had a child, and she said, "Well, Dad, she can't ride with you in the car." I said, "Why not?" And she said, "Well, if you get pulled over, child protectors are going to come." And I said, "All right, I'll get a driver's license." But I've gotten many tickets and I haven't paid a one. And the same with the IRS. To me, and you probably do the same thing in your court. I conditionally accept the offer. I don't use that kind of really that language, but hey, I want to pay. If you just certify the debt and show your certificate, your delegation of authority, we don't have a problem at all. And I went through the whole grand jury scheme with that attitude. And I didn't answer one question they had until they produced the evidence that they have the authority to even speak to me.
Right.
I got a cough. I'll let you talk.
Well, Chappie, you just reminded me of something. The famous actor and movie producer, not exactly kind of infamous, but Woody Allen said that 80% of success is showing up. And this, to beat the IRS, you got to show up. And that means when you get these certified letters, notices of deficiency, determination, intent to levy, then you've got to show up. You've got to exercise the statutory rights that you have, shut them down, and then you can raise, within reason, you can raise your arguments, provided that first you show that you're credible and that you know what you're talking about. So, for example, if you go into tax court and you can't read the tax court rules correctly, and you make a mistake and they nail you on it, because you weren't able to follow that simple rule, they're not going to listen to you pontificate about the District of Columbia Act of 1874 or the Treaty of whatever, and whatever other legal arguments that you have. You can't even abide by a simple tax court rule. So you got to show credibility first. If you know what you're talking about, if you follow the procedures, you put the IRS chief counselors to the procedures and you hold them to them, then they have to give you credibility. Your arguments will be taken a little more seriously, and slowly but surely, will come a day, as I say to Lysander, from time to time, what do you think is the more so-called frivolous argument, Lysander? Wages aren't income, or in 1868, when they enacted the 14th Amendment, a man could marry another man?
Yeah.
That issue, the Supreme Court had ruled in 1971, that wasn't even a federal question. That was frivolous. But you see what happened. And there's a lot of cases like that. Look at we were just talking about our Second Amendment right. How many years did they lord the 1939 Miller case over us? Well, you don't have a Second Amendment right to keep and bear arms unless you're a member of a militia. That's what Miller said in 1939. Well, in the last several years, the Supreme Court has issued 3 major Second Amendment opinions that said, no, you've got the individual right. You've had it all along. Well, someday that's going to come for the federal income tax. In fact, there's a big income tax case about the 16th Amendment pending before the Supreme Court right now.
Oh, that's interesting.
Yeah, it's called the Moore case, Moore versus United States, and I mean it has to do with an esoteric tax issue, so-called mandatory repatriation tax. But the question before the court is about the 16th Amendment and whether or not you have to realize so-called income. But in addressing that question, they're going to have to get into the history of the amendment. What is the meaning of income? And a lot of stuff that could turn out favorably for us, given the composition of the court right now.
Yeah, a
Yeah.
lot of it, what you just said, has already been defined, like income and everything. So, yeah, they
well,
got to
for
follow
example,
suit.
the
We spend a
famed
lot of our
Eisner versus McComber case is going to take center stage in that case.
Yeah.
So, Lysander?
we spend a lot of our time in tax court cases. We don't always get them from the very start. In fact, we usually don't get them from the very start. We get them after our client has already written a petition and suffered, humiliation at the hands of the court. We spend a lot of time just tidying up their reputation, wiping the Hendrickson off them, we call it, and it works. It can happen, but it takes time. If you brought in and opened up with arguments that the court has determined are frivolous, and it's easy to look up case law to find what the tax court has said, concerning various patriot issues. And if they've called it frivolous before, don't raise it again. Most people go into the tax court, and I'm guilty of this myself in my first cases. I was just going to tell the tax court what the law was. I'm sorry, when I didn't do any research on what the tax court had already decided the law was, and of course I got creamed. I didn't know the rules very well. Ed's point that if you can't learn the rules, how can you expect to be able to lecture the court on esoteric tax law that goes back to the 1860s? You can't. If you haven't mastered the rules, you get no respect. Not only that, but I saw many pro se tax court petitioners lose on procedural issues. They didn't do things right. They did them wrong, and then they went away feeling that they'd been done a terrible injustice. But the court didn't have to resort to injustice. It could beat them on procedure.
Yeah, unfortunately, the rules matter and the law doesn't.
Yeah, the rules matter more than the law.
Yeah.
You don't get to tell the tax court what the law is. I'm sorry, that ain't going to happen. The cases we win and the cases we do best on have factual disputes. They have factual issues. Interesting enough, the IRS has a harder time establishing facts than it does spouting off about the law, because they have nobody with firsthand knowledge,
Right.
nobody with personal knowledge of anything. So everything they submit, all the transcripts, all the third-party reports of revenues of various kinds, they're all hearsay. But the court, of course, is not as strict as they might be about enforcing the rules of evidence. But the IRS has much more trouble with facts than they do with the law.
Yeah, we had them going around in one of my cases with them. We had them going around with computer generated documents. I want to know who put the information in the computer. Absolutely. And I want to talk to that person.
Yeah.
And they would never do it. And they still judge against me because obviously there was something that I missed.
Right. They hate to see people bringing up evidentiary issues and procedural issues because they can't call it frivolous. All they can do then is make a corrupt ruling. And they would really rather not have to make a corrupt ruling if they can avoid it.
Yeah.
Right. Chappie, that brings up an issue. We don't have, if the pro se petitioner or pro se person is going to the tax court, even if they're not doing something right, at least they're headed in the right direction.
Right.
What we're concerned about, and I know that a lot of people in your audience are facing this, is that what if you're someone that doesn't believe in going to tax court, then what remedy do you have when they come after you with these notices of deficiencies and the assessments, the liens, the levies? They take you to district court and sue you. They foreclose the lien on your home and they evict you and sell your home. where's the remedy? That's what we're trying to get across to people, is that you do have remedies if you exercise your rights correctly, and that's in the tax court.
Well, like I said in the beginning of the call, there's no way on this God-given earth that I would go back to tax court unless I had somebody of people like you that been through it. You know, like I wouldn't try to build a 747 and try to fly it because I have absolutely no experience. And I couldn't sell tickets to get on the plane, and the same thing is with court. Now, if you're summoned to court, that's a different story. You know, I don't need the rules. I don't need nothing until they can prove they have jurisdiction. But in tax court, you give them jurisdiction in order for you to get through the process, which if you do it right, you do it correctly, take your time, it will stop them from taking your money out of your paycheck. It will stop and suspend the lien on your property sometimes, and it will give you a lot of time to breathe, and where you could pay for the counsel that you're getting instead of giving it to the IRS where it goes nowhere. Is That's a
Right.
pretty
You
fair
just
assessment.
That's a pretty fair assessment. It is. Yeah.
Yeah.
you just hit on something really big that to us, Chappie, is that what we offer is peace of mind to people. We deal with a lot of people, and we know, and I have had this experience personally. It's not easy being a patriot. It's not easy fighting the IRS. You have a spouse, if you're married, that normally is not quite as enthusiastic and on board with this stuff as you are, and you're spending all your time with this and research, and the liens and the levies are coming, and it's usually a woman for whatever reason, getting nervous. We've seen a lot of marriages in the patriot community go
up in
asunder.
smoke.
Yeah.
Yeah.
Very sad.
Yep.
Very
And
sad.
because of this, and a lot of this stuff could have been avoided. For example, you just touched on something. We had a guy, he was working with another group, and they actually did have him petition tax court over $1 million deficiency determination. Okay, so they did go to tax court, which was a good thing, but they gave the tax court all sorts of stuff that they call frivolous and whatnot. So when they got the guy's petition, they read it and they said, well, this doesn't even state a claim that we could grant relief on, so we're dismissing the case. You now owe $1 million. Well, this guy came to us. Fortunately, within 30 days, speaking of the rules, the tax court rules say that you can move to vacate a decision or for reconsideration of an order within 30 days. So all we did, Chappie, we did up a great petition for this guy, no so-called frivolous arguments. Boom, the case is back on. The assessment can't go forward. They can't collect. That was like a year and a half ago. The case has hardly moved forward.
Right.
Wow.
And one of the reasons is because we found in this guy's documents, notice a deficiency that added up to over $1 million. There was a $209 math error. They added something where they should have subtracted something. And so all the figures, therefore, on the notice of deficiency were no good. And it shifts the burden of proof to the respondent, to the IRS.
Yep.
Every question of unreported income that is on that notice of deficiency, now the IRS has the burden of proof on it, and not this guy, which is one of the reasons it ain't going anywhere right now.
Yeah.
So,
And now without that, go ahead.
No, go ahead.
Oh, without that amended petition that we filed, Chappie, this guy would have been facing
Yeah.
$1 million assessment. And when that happens, you can be darn sure that there's a live revenue officer that will appear on your doorstep ready to collect that when he can.
Yeah, this won't go to the automated collection system.
Yeah.
And you don't want to have to deal with this. If you don't have to deal with the IRS, then you don't, you shouldn't. If you can stop them in tax court, then you should do that. If more people, unfortunately, they do statistics every year at the IRS. Okay, so many people petition, so many people ask for a collection due process hearing. The percentage of people that do that it's shockingly low percentage, like 5%. If we could just bump that up a few percentage points more, I mean, that would almost paralyze the system.
Yeah. That happened during the liquor day and Al Capone, that people flood the courts so much they couldn't fight it anymore. They legalized alcohol back then, as I understand it. Like,
Yeah, so it's the same principle. Again, these guys are working off a budget, and we're scheduled for another government shutdown here on November the 17th. And so they have funding that they're allocated only so much. They can only handle so many cases. Tax court only gets about 25,000 cases a year, and we're a population of supposedly 290 million so-called taxpayers. So that's really small. If we could bump that up, these guys wouldn't even be able to move forward against most of us. And while they're coming after me, for example, they're not coming after you because they don't have the time.
Right, exactly. Like I know a girl that she the IRS, she pays her taxes, and happened to be my daughter, but she pays her taxes and everything, and she gets a thing from the IRS because she gets these things from Amazon to try, and she gets it for free, but the deal is she has to pay taxes. So she got this, she got that, she got this, and it added up to a bunch of taxes where she went to H&R Block and they said, well, what did you do with it? Well, I gave it to one of these outlets, you donate stuff to, and they sell it, and a thrift shop, and it wasn't really good, and so forth. So they took off the value and all that, and they submit to the IRS, H&R Block, and she didn't owe the extra taxes. Well, the IRS wrote back and said, well, we never got your letter. We're assessing now, you owe this much. So she took it back to H&R Block, and they said, no, they got it. Here, we'll do it again, and this time they'll get it. Well, now she gets a letter saying that she can't go to tax court because she had her 90 days. And I said, she said, do you want? Yeah. And I said, well, do you want to go to tax court? She goes, nah. And I said, okay. So I don't even press upon my daughters or my family. If they want to pay taxes, hey, go ahead and pay it,
Well, it's interesting you should mention that because there's been recent court decisions on deadlines for tax court filings, and they have been found not to be jurisdictional. So that if you have a reasonable excuse for having missed your deadline, you can apply to the court and say, I'm sorry, I got good cause why I missed my deadline, and I want to have my case heard, and you can still do it. It sounds to me like she's got talk about a reliance defense. H&R Block figured it out for her.
Well, H&R is supposed to. She's finding out if they're going to argue for her. And I said, well, you find out because they will argue for you.
Oh, will they? Well, that would be nice, but
I'll make them.
She could subpoena them for their opinion if she had to.
Yeah, exactly.
But
Well, the
it's
thing is,
interesting.
Chappie, is that you can go and have an H&R Block or any other, they supposedly stand behind their work, but they can only do so much. They're not going to take you into tax court to, litigate whatever issue this is. So,
Yeah, but you can
unless you can
subpoena
get
their records. Yeah.
Yeah, unless you can get it resolved at the administrative level, you're pretty much not going to get any resolution. And if your daughter happens to live in Pennsylvania or New Jersey or Delaware, she might have a chance to still petition the tax court, even though she was filed after the 90-day deadline, or that deadline had passed. But that's what Lysander was saying, that there's courts now that have said that these periods of time to take action to exercise your rights, 90 days, 30 days, 6, whatever it is, they're not jurisdictional, meaning that the court can entertain them even though they're late. And that's an enormous help. Yeah, we've gone back into our archives, and people that we thought, people that we thought were lost because they had missed their collection due process rights or their tax court petition time, we can now go back and we can petition the tax court now, or even file a collection due process hearing request.
Yeah,
and
just for the very reason of the recent court decision.
Right.
Yeah.
That's the best
so
excuse.
If they have a plausible, excuse, and again, the IRS can always waive that defense. They could say, well, the statute of limitations is what they would call the 30 or 90-day period. They can waive that and say, no, we'll just argue on the merits. If that happens, you're home free. No assessment, no collection.
Yeah. Okay. Well, look, we got 10 minutes. I'd like to keep this in about an hour. I'd like to, are you guys willing to take some questions?
Sure.
Okay.
Yeah, absolutely.
Okay. Anybody wants to raise their hand?
I see a couple names on this list of people I know.
I'm sorry?
I see a couple names on this list of people I know.
Oh, okay.
From this fight.
Okay, does anybody want to have any questions? Okay, let's see. We got Mark Peters. Go ahead.
Can you hear?
Yeah.
Well, yeah, we can hear you. Yeah, go ahead.
All right, I'm sorry. I was just thinking of some of the things that were brought up, and I have a friend of mine who Bill Lehman. I hate to bring his name out in the open like that, but he had his Social Security completely taken away from him, 100% of it, and that's been going on for over probably 3 years or more.
Yeah.
So he's losing like $22,000 a month that he isn't able to collect because they said
You mean 2,200?
Whatever it was.
Right. If he's collecting $22,000 a month in Social Security, he has one hell of a job.
Yeah.
I'm sorry.
I want to eat the breakfast he eats. Yeah.
Yeah. So no, I'm sorry. It's $2,200 a month or $2,000 a month. Anyway, and the bottom line is he's been sacrificing now and having at his age still working at 71, soon to be 72, and he still would like to recover back his Social Security that he depended on to live on, and he still has to work pretty much full time to pay off.
Okay, hold on, Mark. Mark, is there any hope? Is there any hope for this guy, Bill Lysander?
Well, it's impossible to say without looking at the details of his case. We don't know how the debt was established or whether he fought it, what he did to oppose it, if he did anything, whether he filed the tax return. If he filed a tax return and said he owed those taxes, he owes them.
All right, we'll give you contact information at
Here's
the end of
what
the
I was
call.
going to suggest. If people would want to text me to this number, let me give you the number, 859-552. Sorry, 552-3000. I knocked my headset off for some reason. 859-552-3000.
859-552-3000.
And
okay, that's the number.
If you text me, we will give you a half-hour consultation on the details of any case that you want us to review. And it can be in the tax court, but we work in other courts as well.
Okay.
We
No
can call ourselves,
doubt.
we're procedural technicians. We can do what we do in any court, and we've done it in district court, bankruptcy court, a number of appeals courts, and the tax court, of course. I mean, the reason we do most of our litigation in tax court is that's where most litigation occurs in federal courts, in tax court. So, but,
And from Mark, is that the caller's name?
Yeah.
Mark, we just won a case within the last couple of months from a guy, doctor in Florida, that was facing the same thing that your friend is facing, the 100% Social Security benefits levy. And here's the thing, you know that there's a 10-year collection statute of limitations after assessment for the IRS to collect. Now they claim, as they claimed in this case, and it would claim in your friend's case, is that if they put the levy on before the 10-year period expired, that levy is good until he dies.
yeah, that's a perpetual levy. Unbelievable.
Perpetual
Wow.
levy.
Yeah.
Yep. And
Yeah.
we got that levy stopped, and we got the guy to get a refund from the IRS from overpayments
Outstanding.
after the collection statute
Okay.
had expired.
That's interesting. If just real quickly, I have had that put on me with the Wisconsin Department of Revenue on a perpetual levy, and then they never pursued it. But I didn't know whether maybe that was just a clerical error, or if it was something that perhaps they wanted to just put it in the records that it was there. I
Oh, you
don't
mean
know.
they're-
Now
I
that you mention
forgot.
it.
They're
I
not
forgot,
actually
Chappie,
levying.
we didn't mention we also do state tax issues.
Yeah, we'll do state
So,
taxes.
a lot of people forget that if you're taking a position vis-a-vis the IRS, your state is watching you if it has a state income tax.
Yeah, in my state we do, and I have had, I had the, as Chappie already knows, the U.S. Justice Department served me on a summons from back in May of 22, and now we're still in the process of battling this an ongoing thing. But in the interim, my wife has been hit 3 times in levies from the Wisconsin Department of Revenue, and
Oh,
levied her a little Social Security. All of it was Social Security, and yet they're only got by law supposed to only be able to remove 15% of that Social Security in the eyes of the law, at least. But they
Yeah,
don't. I don't think.
they
give a shit.
interpreted, they interpreted their way out of that limit.
Well,
It's
if you
just
if you
slick.
got Lysander's number to text him, if you text tax help to that number, then we'll arrange a free 30-minute consultation with you if you want to bring up these issues and send us paperwork. We'll kind of give you kind of an overview of where you stand.
Okay, I got another caller. Oh boy. No, okay, wait a minute, he's gone. Okay. Let me get here. Lower hand. Go ahead, Joshua. Joshua? Unmute
Hello, can you hear
yourself.
me?
Yeah.
Can you hear me?
Yeah.
I can hear you. I can hear you.
How you doing, everyone? From a previous Zoom call, there was reference being made to the 1040 information package that states that either a person could submit a letter or a 1040 confession form. But one thing that I was looking at is it says if you are liable. So if you're not liable, that means you don't have to file. And as you know, Payman Motardeh, who I've been listening to for a very long time, he points out that it is a person who files a 1040 confession form has 8 times a higher chance of being indicted as opposed to someone who does not. But as far as liability is concerned, which is under subtitle A, that's mentioned on the W-4, I think that's the main thing, is to establish, whether or not you have liability, and if you don't have liability, to have a very strong foundation to show that. So
Okay,
that's
excuse me,
basically.
Joshua. Do you have a question?
Yeah, well, basically, I just wanted to mention that. Oh, well, I do. New York State, they don't follow federal or state tax law. They own tax law. And there's a particular statute, and I probably want to speak to Lysander about that, that they use, which actually says tax warrant without a court order. And they've been abusing that statute in such a way that it shows that it's unconstitutional on its face and as applied. And I just wondered if you'd be willing to look at that statute. And
Well,
some of
they
the
got
things
Trump in court without a jury, so
Yeah,
they could do
I'd-
anything.
I'd be happy to. I know New York is particularly brutal.
Yeah, just
yeah.
text tax help to that number.
Right.
If you got the number, I presume.
Yes, I do.
Okay.
Yeah,
Okay,
text
so
up with
what
it,
you
we'll
do,
talk to you about
people,
it.
what you do is you type in tax help at that number, okay? Okay, oh boy.
Give the number again, Lysander.
Yeah,
Oh,
it's 859-552-3000.
Or people, you can email me and I'll send it to you. Okay, oh boy.
Yeah, I'm just curious if there is a way to guarantee that if you have somebody coming of working age, to prevent them from ever becoming a taxpayer in the IRS's eyes, like something as simple as not filing a 1040, or is there anything like that?
You got a social security number?
As of right now, no, and I don't plan to get one.
It's interesting. There was a case long ago about a woman who wanted to get a job, not a big important job, but a job at a fast food restaurant or something. She didn't have a social security number, and they wouldn't hire her, and she sued them.
Hold on a sec. I have to butt in and ask. You never had a social security number.
Oh, sorry, I'm not talking about me. I just had a daughter,
Yeah,
and I don't plan to get her a social security number.
good.
Oh, okay.
Well, I mean, it's interesting. She's in a unique situation. And like I said, this court case decided when all was said and done that she didn't need to have a social security number to work in the United States. Now, this is something that is not broadly known. Employers think they must get a social security number from you, and that if they don't, then they can't employ you, which is absolutely wrong. Yeah, I don't know if you want to set yourself up for a life with no IRS. Don't ever get a social security number, and don't ever give it to anybody who asks for it.
Do you happen to have? Can you share that that case you were talking about?
I'd have to look it up.
Okay,
But
sure.
But I know there is such a case.
And if you want to know more about it,
Send me
tax
a
help.
text. Yeah, text me tax help and remind me.
Okay, that number, just the one you've been sharing.
Right. Yeah.
Okay.
Remind me of what you're looking for. I'll try and find that case.
Sure. Yeah, I think we're in the same area anyway. But yeah.
Okay, well, thank you, oh boy. And
Anybody else?
okay, is there anybody? Oh, wait, two popped up. I thought I was going to get out of here. All right, hold on. Okay, go ahead, John. What happened to you, John? Okay, John. Oh, there's two Johns. Okay, the John that raised your hand, will you unmute yourself?
Can you hear me now?
Yeah.
There we are. Yeah.
Yeah. There was also the case with the Taco Bell case where the two kids wanted to work for Taco Bell during the summer,
Mhm.
and they didn't give the social security numbers, and they didn't hire them, and they sued the Taco Bell and they won.
Yeah, they did. Okay. All right. Yeah, I mean, they're voluntary. You don't have to get a social security number.
Yeah, I think that suit, I know I'm very well used to be had a lot of knowledge about that case. I don't think they ever won the $1 million, although I think they did sue them. And if you go to a Taco Bell employment sheet, at least as far back as about 20 years ago, where it says Social Security, it was voluntary. You didn't have to put it down.
Right.
They did change their application form, but nobody else. Okay, let's see. There was one
last
more. We
one.
got Chuck S.
Chuck S.
Go ahead, Chuck.
Or Chuck.
Chuck? Talk to me, Chuck.
No, I can hear him.
Chuck? Chuck, I see your mic moving, but we don't hear you.
I hear him.
I hear him.
Oh, well, let me shut my mouth.
Yeah, I hear him too.
Okay, all right, go ahead, Chuck. Yep. Mhm. Mhm. As far as I know, they ignore it. They ignore it.
May I interject?
Sure.
Okay, well, Section 83 doesn't say wages. What refers to wages is Chapter 24, Subtitle C, Employment Taxes. So when the government gets into using that argument, saying that, oh, really, what he's saying is that wages is not taxable income, they have to be corrected on that, because when you go to 3402, it tells you that every employer making payment of wages shall deduct a tax, et cetera, et cetera. But then when you go to 3402N, it tells you that an employer shall not make a deduction from deduct a tax from wages unless there's the W-4 has been put in place where you are claiming that you have no liability or or you don't anticipate having a liability. It's right there. That's the 3402N. So they tend to see, they have a case that has been obviously a lost case, and they always like using that case, when trying to, argue or say that the defendant is arguing a frivolous claim and has been repeatedly dismissed by so many courts and this, that, and the other.
Mhm.
So I just wanted to bring clarity to that.
Sure. Thanks. And you seem to be very familiar with it. I believe there's a definition in there that involves the word includes. And I
That's
can't remember.
7701. That's 7701C.
Right, and there are several definitions in the definition section that use the word includes, and this is where the mischief lies in their definitions. I had actually, there's a guy here. We wrote a memo on that issue many years ago now, but they still throw it up in our face. It was Scott Nook's case where we argued the definitions of the terms, and that the word includes only includes items of similar type and kind. Well, the court just said includes doesn't exclude everything else. And that's all they said, as if includes was absolutely meaningless and didn't limit the definition in any way. They could apply it to anybody they wanted to. And that's how they work around it. They just rework the definitions.
If I may, all you have to do is cite Gould versus Gould and Meese versus Keene, and there's a couple other cases along with that, and that would put that to rest.
Well, I'm sure we did. I don't have the memo in front of me, but those sound mighty familiar. Doesn't matter what we cited. He didn't.
It's a U.S. Supreme Court.
He didn't refute our citations. He just made up the law right there on the spot, which is what they do when they're desperate.
Yeah.
And the problem with the Section 83 argument, as it's called, is that Dave Marland has been raising this issue for years, and unfortunately, it's always declared frivolous and nonsensical and what have you. And, he's had his own personal troubles. So, I knew Dave he lived in my city in Washington State. So, I've known him for years. Great patriot. But, over the years, when these arguments don't work, the answer is not, as the saying goes, to keep doing the same thing, to do it a little different.
Right.
And come up with a new approach. And that's where we come in. We have that new approach. And we call it intelligent confrontation because The old methods don't work. And as I said, now that we have access to all this information that our opponents have, we should hardly lose.
Yeah, you're right. Okay, we got another question from old boy, and I think we'll wrap it up. Go ahead,
Okay.
old boy.
Just real quick, does anybody have any similar cases with regards to opening a bank account without a social, where somebody sued them in one?
I
Don't
haven't
recall
had
that
any
if they
experience with it.
sued them in one, but I mean, they always say that it's voluntary to disclose it, but then again, they're not required to open the bank account for you.
Right.
So,
Yeah, I mean, the law,
Yeah,
if you point it out to them, it says they have to ask, but it doesn't say you have to tell them.
right.
But when you don't tell them, it becomes then a matter of internal policy. Oh, they're not gonna say it's the law. They're gonna say, we want your social security number. And
Yeah,
we're not
some
opening
people-
this
I see where you-
account.
I
Say
see
what?
where you're going with this in that if you're not on the radar screen with information returns and everything else, 1099s, W-2s, then chances are, you're not going to have many IRS problems, if any, over your life. But to actually get to that point, now, unlike when we grew up, you're in the hospital, you're the mom in the hospital, they're bringing you a clipboard, and here, fill this out, you get the social
Yeah.
security number for your baby right now.
Yeah,
Before, you didn't get it until you started your first job and you were going to work.
yeah, they did that to my granddaughter, and my daughter didn't want to do it, and she said, "Well, we have to call child services." So they scared her into giving her. I had to leave the hospital. I was so angry.
Yeah.
Right. Well, Chappie, I know you got to go. I want to leave your listeners, Lysander and I want to leave your listeners with first, thank you so much for having us on and this conversation about the tax court. And, we just ask people to keep an open mind. Don't be kind of scared about, invoking the tax court's jurisdiction and somehow that's going to, impact you negatively. It's actually going to be a positive thing if you approach it in the right way. So if you do that, which we can help you do, then you'll be fine.
Well, and like I said to before, there's so many ways of doing things now with the technology that we got, with the experience that people have gone through. Many people. I talk to many people during the course of a day, and and the first thing when people are new to this, the first question they say I ask is, how come you don't want to pay taxes? And if it's because they just don't want to pay, and because Joe Blow's doing it, I say, well, I'll tell you what, you pay your taxes so you don't have to look over your shoulder. You learn what it takes not to pay taxes, and then I can put you to the right person, because that's what I'm doing now. I'm kind of retiring from all of this. I don't want to get into anybody's case anymore. I'm getting too old for this. But there's people like Lamar, there's people like Paul Hansen, there's people like Lysander, the tax group here, that can help people, legitimately help you, where I feel comfortable. And like always, people, if you go to somebody that I support, and I support everybody that I bring on to the call, and unless something something happens, but I will support you. In other words, if they're busy and they have questions, I'm pretty sure I can answer most of your questions in the way that they would answer it. And if I have doubt, I will contact them as well for you, just to be sure, or be on a call with you if you want me. Not that I want to be, but I'm looking for winners. I'm tired of people losing. Even if you break even, it's better than losing. would anybody disagree with me on that?
Right.
Thank
Well
you.
said.
Well said.
And with that being said, I'll let my little heart tell you.
God bless America, and this call is officially over.
Okay, well, I'd like to thank everybody for coming to the call, and we will talk to you soon. Thank you.
Thank you so much. Okay.